The information provided on this show does not, and is not intended to, constitute legal advice. Instead, all information on this show is for general informational purposes only. The information provided is not a substitute for legal advice, and we recommend viewers consult an attorney for specific legal matters.
All right, two things before we get going. Please just remember to subscribe to the Condo Craze and HOA's channel on YouTube, where you can watch the show live, ask questions, and if you miss a live show, you can watch a prior show anytime you like. Don't forget, please, to hit subscribe and like, and of course, join our Condo Craze email list. We now got like 11,500 on there. It just keeps getting bigger and bigger.
Whoa.
Yeah, and by joining each week, you're going to get emails about the show, our blog, our seminars, our newsletters, updates on the law, and a lot more.
And you can also follow us on Facebook, and you can also see us on TikTok and Apple and Spotify. Don't forget, you can download on all of those platforms. We are there.
Yes,
and make sure you like, subscribe, and all that good stuff.
And of course, we do a blog every single Monday morning at hoa-condoblog.com. Tomorrow's topic, condo director education.
Ooh.
What a tremendous change in the state of Florida, and we'll talk about that. All right, as we know, this legislative session made it clear that 2024 was really the year that the unit owner fights back and gets heard. That's what 2024 will always be remembered for. And in fact, there were even changes this year giving owners greater protection when it comes to the law involving, what is the thing they fight about most, basically, access to condominium records.
Right.
So a lot of changes, a lot of more benefits now, a lot more protection to condominium owners when they ask for access to records. So for example, 718-111, parentheses 12, that statute's being amended to state that the association's accounting records must include, but are not limited to, so these are now things unit owners can get, all invoices, transaction receipts, look at this, deposit slips that substantiate any receipt or expenditure of funds by the association. So if the association got money or received money, period, we want to see the proof of it. The unit owner is allowed to see it. Again, even including deposit slips, copy of all building permits, a copy of all satisfactory completed. How about this? Board member educational certificates.
Oh, you're kidding.
Yeah, I mean, I teach that all the time. When at the end of the seminar, you know, I give out.
You have for 15 years.
That certificate, right. And that certificate becomes an official record of the association. And believe me, unit owners will ask to see it because they want to make sure that their board members are in fact certified.
So if the association is still doing things the old-fashioned way and making deposits by filling out a deposit slip and going inside the bank to see the teller, that deposit receipt issued by the teller is now an official record of the association, and unit owners are entitled to see that?
Absolutely they are. And in addition, I say every time when I teach the board cert class, again, that certificate at the conclusion, you must take it and make a copy of it, right? You can hold on to the original or even hold on to a copy, but there has to be proof filed with your association that you are in fact certified. So you can give the original to the secretary or the management company. They have to have a copy. So if someone comes in and says, we want to see it, unit owners are entitled to it. But you can also keep a copy for yourself.
But what about the deposit slip, the picture? Can you put that on the website?
Can you do it? Yes. And you'd be surprised. The website statute doesn't require as many things as you think that have to go on there. Actually, you'd be surprised it's very limited as to what has to go on there by statute. Now, just because it's limited by statute doesn't mean you can't add more things.
Yeah, it's always
better.
better.
I'm in favor of adding, just throw everything on there that you can possibly throw on there. And then no fights about access to record. That's how I see it.
There are fights, and a common complaint that we have heard from condo owners throughout the years is that when they ask to see the records, they're eventually pointed to dozens of cardboard boxes or filing cabinets and told to search through them because the records they want are somewhere in there.
Yeah, and
Go
that
fish.
happens. That's a very common complaint over the years. I bet you a lot of people who are watching right now have been down that road. They've asked for access to records, and they're told, yeah, they're somewhere in that room over there.
Out.
Yeah, here's 25 boxes. Go search through those boxes. Very common complaint. But here's a new law, and it prevents the association from sending the owners now on a fishing expedition. That's no longer allowed. So here's the new law. The official records must be maintained in an organized manner that facilitates inspection of the records by a unit owner. In the event, how about this one, okay? So they got to be put in a manner that it's easy to find, right? Look at the next sentence, brand new law. In the event that the official records are lost, destroyed, or otherwise unavailable, the obligation to maintain the official records includes a good faith obligation to obtain and recover those records as is reasonably possible. That is a humongous change to the law. Big
That is
change.
really big. I mean, I would think that the obligation to obtain and recover lost records is a major.
It is.
Major
You know, unit owners can't now simply be told, "Sorry, we don't have it. The record is lost. You know, now go out on your own way. We can do."
We don't get paid here.
Yeah, so now, you know, they were actually told, you know, turn around, get lost. We don't have it, right? But if a unit has been now told that a record is lost, the unit owner now should routinely follow up in writing and ask, what efforts are you making to find those lost records? What efforts are you making to obtain those lost records? Because now under the statute, you have to do it.
That's right.
Yeah.
I think Robert has a story about you went in to ask for records, and until you get the records, you don't have the records.
Absolutely. Don't let them, you know, put a bunch of boxes in front of you and think that that's your job to find it. It's their job to provide it until they do.
That actually happened with you.
It has.
In real life.
In real life, yes.
Yeah, you went into your association. What happened?
They put, I want to say 8 boxes full of records in there, and they said, have at it.
Right, and you're looking for that one needle in the haystack.
Indeed.
Yeah.
So even though they made the overture of giving you the boxes, they haven't given you the record
Correct.
until you find it.
I reminded them of that. I said, until I have the record that I'm looking for, you're not fulfilling the request.
Right, exactly.
There you go.
Exactly.
And so here's the new law that shows why it's great for the association to have a website.
Right. You were saying, here we go, why is it great?
And Robert will be able to go on there
Right.
instead of fishing in the boxes.
That's exactly what the new law says.
Yeah,
Right?
so
why is it great to have a website?
If
Tell us
it-
what the new law says.
If the requested records are posted on an association's website or are available for download through an application on a mobile device, the association may fulfill its obligations under this paragraph by directing people to the website or the application. All persons authorized to request access, which would be homeowners.
Yeah, exactly. So now
Or-
here it is. You have everything on your website. Person comes in and says,
Problem
I
solved.
want this record. If your website is up to date and there's a lot of records on there, you don't have to say, okay, we're going to help you in this office. You can say, go to the website.
There you go.
And you know how many fights that's going to prevent? You know how many potential arbitration cases that's going to prevent? It's going to save the association money in the long run. It's really, I think it's great news for a condo association. It's now perfectly okay to say the records are on the website. Go there if you want to see them. It's going to create less traffic in the office, that I can tell you.
Big time.
Less arguments, and the important thing to remember is that this only works, though, if your website is up to date and someone's aggressively updating it.
Make sure that your CAM isn't running the website, that your association actually owns the
Absolutely.
website.
You want to make sure that, God forbid, you split up with your CAM,
You have your
that
website.
still stays with you somehow. Exactly,
Yeah, get
right.
a webmaster
Yeah.
and have them set it up
Yep.
for you.
But that should stay the ownership of the
and
association.
that should be part of your budget
Yeah, absolutely, 100%.
because it's expensive.
Put a line item
There
in
you
there. Very
go.
good, Karen. Put a line item in there to maintain the website. 100%.
Keep up with it and make your life easier, and you don't have to make the deposit inside the bank with a slip. Okay, so I know that there's still so many new laws that have passed that we haven't spoken about yet.
Right. I'm telling you, there's so many things that happen this legislative session. But guess what? Everybody's going to have to keep tuning in every Sunday if they want to learn them, because we promise to keep teaching them, and I promise we ain't even close to finishing yet. So there you have it. Let's find out what our listeners think about the new statutes involving access to records. Call us here in the studio, 717-GLAZER-8. Again, that's 717-GLAZER-8. That's 717-452-9378. or drop us a question in the chat box on YouTube. We'll be back right after this.
There are very large management companies and there are very small management companies, and I think Affinity sits somewhere in the middle of that, where they are big enough to provide you with all of the back of the house services, the accounting, the infrastructure, the support systems, but small enough to be high touch.
We believe at Affinity that we do the 9 to 5 so that you don't have to do that.
Oh no, an unexpected leak. Jay, you know that's no way to solve a roof problem. Call Best Roofing. We solve roof problems.
We are DMI Paving and Seal Coating, Florida's parking lot experts. We specialize in asphalt paving and repair, including pothole repair, seal coating using JC7 or polytar, concrete curbs, ramps, and walkways, and striping and pavement marking, as well as ADA compliance. We service commercial properties, including homeowners associations, apartment communities, shopping malls, warehouses, stadiums and arenas, and more. Experience is worth more than anything in an industry like ours, and our staff has decades of it. We have specialized equipment for any job, regardless of size, saving you time and money. DMI has a reputable history. We have been in business since 1956. We serve the state of Florida from 6 locations. Let us bid on your next parking lot project.
For mitigation after a catastrophic event, building restoration, repair and remediation consulting, or Senate Bill 4D inspections, please visit rimkiss.com.
So, welcome back to Condo Craze and HOAs on our YouTube channel. Seems like we have the audio problems all sorted out. Sorry about that. If you want to give a call and ask Eric a question, he's board certified in Community Association Law, 717-452-9378. That's 717-Glazer8 with a Z.
Let's go to the first question. A lot of questions, on the board. Robert writes in, please clarify if you were board certified in 2023, do you need to be recertified due to the new statutes? And the answer to that is yes. In my opinion, absolutely yes. Why? Because you haven't learned any of these new laws that just passed if you were board certified in 2023.
There's continuing education anyway.
And there's continuing education. So look, take the class, and then going forward, every year you'll have to take you can take a 1-hour course. So the way that it's designed is you have to take this 4-hour course the first time, and then every year if there's new laws, you got to take a 1-hour class, okay? I'm not going to do that because there's always going to be people every year that need the 4-hour class.
Right.
The new people that are getting on the
right.
board, right. So I'm not going to go teach a 4-hour class and a 1-hour class. This 4-hour class that I'm teaching is going to include all the new laws that have been passed in the last year. So by taking the 4-hour class, you're fulfilling your 1-year obligation, right? And you're learning things all over again, some of the things. So what's the harm?
So it's a 4-hour class every year.
That's how I'm going to teach. right?
smart.
Because the bottom line is you're going to get your 1-year credit.
Right.
And
Learn.
you'll learn it all over again, because let me tell you, we throw so much at you in the 4-hour class that there's no way you can grasp everything in one time anyway. So what's the harm taking it next year?
Plus, you feed them and you give them.
Yeah, I mean, you know, it's
Back rubs
it's a nice day. So why not
It is a
come
nice
anyway?
day. And they get to meet you in person.
Right, exactly.
I love it.
Listen, you know, after the seminar is over, I stand at the booth where we are, and I just answer questions for another
sure.
couple of hours.
I'm sure.
So, you know, if you want to learn something that day, that's the day to come. Who else we got on the line? Let's take our first call of the day.
Let's see. Let's go to. His name's not coming up, but I think you should hear the beep.
Don't hear anything.
Okay.
There you go. Who do we got?
Dan from Palmetto.
Okay. How can we help you?
I'm secretary of board association, or my association's board.
Okay.
There are some people who say that I'm not doing the minutes right, and I've been doing minutes for 30 years for nonprofits.
Right.
All that I record in the minutes are the motions that pass. That's
Right.
it, nothing else.
Right.
Because we're supposed to be recording our official business, and if the motion doesn't pass, we don't have to record who didn't vote for something.
Right.
Is this correct?
No, I would disagree with you on one thing. Let's say somebody makes a motion and the motion doesn't carry. I think you should absolutely include that in the minutes so that someone, you know, can argue about later on, hey, you know, we passed something before. How come, you know, it didn't pass? How come we're not enforcing it? And you'd be able to show them, no, look, it was voted upon and it didn't pass. So I think it's very important to keep track of what motions fail as well. So, you know, there's been a lot of talk always about, well, what about all the chatter from the audience and stuff like that? Should that go in the minutes? Some people really make the minutes very detailed. I don't think there's any requirement to do that, but I do think that all motions, whether or not they pass or fail, should definitely be included in the minutes.
Okay, thank you very much.
You got it. Keep going, Rob. Who do we got?
Let's go to Joe from Boynton Beach.
Hey, Joe. Good morning.
Hello, Joe.
Good morning, Karen and Eric. Joe from Boynton. Quick, on the subject of documents, if somebody makes a request for 7 years worth of insurance policy, 7 years worth of work orders, 7 years worth of payments and checks related to pest control, is that acceptable?
Yes. Yes. I mean, the bottom line is all records need to be now saved for a total of 7 years. There's very few exceptions to that. One being the records for elections, that only has to be held for 1 year, because after 1 year it's basically moot. And there are some records that need to be held even longer than that, like all your inspection records, all your structural integrity reserve studies. That's got to be held for 15 years. Minutes have to be held forever. So yes, you know, unfortunately, I guess for you, it's got to be held. If someone comes in and wants all these records for the last 7 years, got to turn them over.
So if minutes have to be held forever?
Yes, forever.
Do they have to put those on the website from forever?
No, I don't think the minutes have to be included on the website,
Okay.
but is it a good idea where somebody could click on the button marked minutes and all the minutes are there?
There they are.
It's fantastic,
It's
absolutely.
like your website.
Yeah, but Joe, yeah, bottom line is, yeah, I think that's what they're entitled to. You know, when in doubt, pick a unit owner has to see it.
Yeah.
You know, it's labeled, you know, if it's an official record, what is an official record? Arbitrators have determined, you know, what does that phrase mean, an official record? And it has to do with any record related in one way or another with the operation of the association. The operation of the association, and that's been defined very, very broadly. If it's a bill for something, yes, that had to do with the operation of the association. The association received a service, the association received a bill and paid it. That certainly has to do with the operation of the association, must be maintained for 7 years. Certainly an insurance policy, absolutely.
Yeah.
Okay?
Thank you.
You got it.
Thanks, Joe.
You got it. All right. You know, let me get back to insurance policies for 1 second. You certainly should be saving your insurance policies for at least the last 5 years,
Okay.
because if somebody slips and falls, whatever, and then they hold their claim for 5
to the
years
last.
to the last minute on the statute of limitations, right? It may be that that policy that was in place 5 years ago, that's the policy that's going to cover the association,
I
not
see.
the one that's in effect now.
Now.
So you always want
Oh,
to make
what a
sure
nightmare.
you cover you can hold on to, I should say, your insurance policies as long as you can.
Because
Okay?
even though that policy is not
It's done and
in
over with, but it
existence
still
now,
might.
it was
correct,
extant at that
correct.
time.
That was the policy that was in existence at the time
Got
of this
it.
incident here. Correct.
interesting.
Absolutely. Who else, Rob? Let's keep going.
Let's go to Robbie.
How are you, Robbie?
Good morning, Counselor.
Good morning.
Robbie Smithers from Tampa. It's our South Hillsborough County. Got a HOA here that I serve on the board of. We have 577 units.
Wow,
I've
big one.
got two pretty big questions, but I'll make them short and
Sure.
see if you can tackle them both. What is the current requirements for rules and regs, publication and retention? And obviously declarations are recorded in the county level, things like that, but our rules and regs, do they have to be published?
No.
And do they have to be
Okay.
available at all times?
There was a statute. There was a statute that was in effect for a little while, and it basically said that the rules and records are part of the official records. All documents in the official records must be recorded to be effective. That was taken out. Okay, so the rules and regulations no longer have to be recorded in order to be effective. Okay, obviously the rules and records have to be somewhere that the unit owners know that they exist. Now, just because the statute doesn't require that they get recorded, is it a good idea that they record them? Absolutely. I think it's a good idea. So you can always tell somebody that you didn't know, that they're going to claim ignorance. You can say, hey, they were recorded. You should have known about it. So I think it's a good idea to record them. Is it required under the law? No, it's not. But then you get into, how did I know that these laws were in existence? Yeah, that's an issue. Let's back up a little bit. Just a little education on how rules and regulations get passed. Boards of directors have general ability to make reasonable rules and regulations, generally regarding the common elements, especially in an HOA. It's basically only the common elements. Those rules have to be reasonable. They can't be arbitrary. They can't be capricious. They have to be reasonably related to the health, the safety, and welfare of the people in your community. And most important, when you're making rules, you got to make sure that the rule does not try to override something that's already in the more important document, which is the declaration. So let me give you an example. The declaration says everybody is allowed one pet, right? Everybody on the board is getting sick of so many pets in the community, so the board says we're getting really sick of pets. From now on, no more pets. Can the board do that by rule? And the answer is absolutely not.
No, 'cause
Why?
it's in the doc.
Because it's in the declaration. They want to make no more pets. What do they got to do? The people have to amend
Change
the
it,
declaration. Okay? So that's a little bit of education on rules. So do I think it's a good idea to record them? Yes, I do. Okay? Can't hurt. What was your second question?
The second is almost like you was reading my mind. The state legislature recently, or a few years ago, prohibited local governments from having breed restrictions. And the pet policy or the pet statute is very specific on dogs, how they have to be determined to be dangerous or not. Can an HOA have a breed restriction from a legal standpoint? And then if that is possible, how do you enforce it? How do you determine the breeds?
I think at this point, is it possible to still say dangerous breeds are
No
not
pit
allowed
bulls?
here, such as, let's just say pit bulls? That's going to make so many pit bull owners angry. Every time I say pit bulls is a
I
dangerous
know.
breed, all the pit bull owners go crazy. They're not dangerous.
Just don't say schnoodle.
I'll just say this. Why is it that every time you hear that a child had their head ripped off,
It's a
right?
pit bull.
Why is it that it's a pit
Mix.
bull every time? Okay, but let's just leave that where it is. So why will I tell you that a lot of these restrictions are meaningless anyway? There's a case that came out of Dade County where a woman claimed that she needed a pit bull as her emotional support animal. Dade County had an ordinance that said no pit bulls in the county.
Yeah.
The condominium said, of course, since there's no dogs, pit bull dogs allowed in the county, they're certainly not allowed here in our community.
If they have Kaufman language.
Well, this law would have applied it anyway because
Oh.
it's a county law that said the dogs can't be in the county.
Oh,
so that
okay.
so that's it. You can't have. Well, she claimed it's an emotional support animal, right?
Oh.
Case goes to court. What does the judge say? We have to listen to the county code. But in this case, federal law, which is her right to an emotional support animal, trumps the local law. She gets to keep her pit bull, claiming that it's an emotional support animal.
Holy smokes.
So basically, everybody who wants a dangerous breed, everybody who wants, like a pit bull forever in their home forever, all they got to do is say, it's my emotional support animal. And we know how easy, quite frankly, that is.
Some guy had
and
an
the
emotional-
dog gets to stay.
Emotional support alligator.
Well, you saw? No, I saw that emotional
He
support
was hugging
alligator.
me.
Anything
And
goes.
it went missing.
Right, but so when he went missing,
missing.
that's scary.
Yeah.
I had him in the apartment. I have no idea where he went. Can you imagine that? Every time we click on something new, I'll just give a little bit of history on it. So what's the difference between an emotional support animal and a service animal? Service animal has to go through training. Service animal can only be a dog or a small horse. Okay, those are the only two animals that can be service animals, like a golden retriever. They're the best,
They're the
right?
best.
They're the best. Incredible, the training they go through.
Well, German Shepherds too.
Yes, they can be, absolutely. But again, it's only a dog or a small horse as a service animal. An emotional support animal can be anything.
Oh, Lord.
Period. You want an emotional support turkey? You got an emotional support turkey. You want an emotional support animal? You get an emotional alligator. You get an emotional support animal. Whatever the hell you want it to be, you get to keep that animal as an emotional. Screw everybody else in the community.
Okay.
They might be afraid of it or whatever.
My
you get
emotional
to keep
support python.
Yeah, right. But person next to you doesn't want a python. You still get to keep your
My
python.
emotional support tarantula.
Right. But that's how currently the law is. No training whatsoever. As you know, we can keep a real service dog next to us when we do the show. You wouldn't know. An emotional support animal like a Chihuahua, right?
Right.
Bark, bark, bark forever. Bother everybody in the community, perhaps. But if that happens, if that emotional support animal becomes a nuisance, becomes a pest, starts to bark, the unit owner won't clean up after it, bites, that emotional support animal has to go. If the snake eats you, for example, right? That snake gotta go. It might be too late, but you have the right to complain about it. Okay? Let's do this. Let's take our bottom of the barrel break.
My emotional support animal. That's a problem.
That's a problem. That's right. So if your emotional support animal becomes a problem in the community, the emotional support animal can get kicked out. All right? Let's take our bottom of the hour break. Taking the calls, 717-452-9378, 717-452-9378. Back right after this.
Is your condominium or HOA in need of accounting services? Look no further. Gerstel, Rosen & Goldenberg is one of South Florida's largest accounting and auditing firms, as recognized by the South Florida Business Journal, and is one of the few accounting firms uniquely specialized to provide accounting services to their growing condominium and homeowner association clientele throughout Florida. With primary offices in Aventura and Boca Raton, satellite offices in Naples and Orlando, and a professional staff of 65, Gerstel, Rosen & Goldenberg is prepared to meet the needs of any condominium or HOA in the state. The professionals at Gerstel, Rosen & Goldenberg also have experience working with timeshares, cooperatives, hotel condominiums, mixed-use buildings, and ancillary operations like restaurants, spas, and country clubs. Put their 25 years experience in your corner. Gerstel, Rosen & Goldenberg, 305-937-0116. That's 305-937-0116 or grgcpa.com. condominium.
Someday, you will need insurance. And for that day, you'll be glad you wrote down Insurco Insurance and Financial Services. Why? Because Insurco virtually insures everything. They're a full-line insurance agency that'll put together the best possible coverage and premium for almost anything. Need homeowners or condo insurance? Call Insurco. Need auto or motorcycle insurance? Call Insurco. How about golf cart insurance or trailer and RV insurance? Just call Insurco for a free quote. They're open every day. From renters insurance, officers and directors insurance, and personal liability umbrellas to all types of business insurance, boat insurance, cancer policies, life, health, and annuities. All you need is Insurco. Get a free quote. They service Dade, Broward, and Palm Beach. Speak English and Spanish. Insurco Insurance and Financial Services. It's the only name you need. Office at 14401 West Sunrise Boulevard in Sunrise, inside Edmore Chevrolet.
Call 954-846-1206. 954-846-1206. That's 954-846-1206.
All over the world, people have plumbing problems. These problems can be expensive and destructive to fix. Have you ever wondered if there was a way to take care of your plumbing problems without destruction and an outrageous price tag? Welcome to Pipelining Technologies, Inc., where we specialize in fixing your problems without demolition and minimum cutting by means of pipelining. Pipelining is the ability to take a pipe damaged by root intrusion or long-term deterioration and make it new. By means of inserting an epoxy-saturated liner into the pipe and allowing it to harden or cure, leaving behind a brand new pipe.
That sounds great. How can I get pipelining in my home, commercial building, or condominium?
Simply fill out our online contact form and a pipelining representative will get in touch with you in a timely fashion, or call us directly at 561-853-5463.
All right, welcome back to Condo Craze and HOAs. If you have a question, you can put it in the chat box on our YouTube channel, or you can call Eric. He's board certified in Community Association Law. 717, it's toll free, 717-452-9378.
All right, I'm going to go to the board. James Diaz writes in, really important question. My HOA does not have Kaufman language. Do the new laws apply? They're saying they will continue to enforce the pickup truck ban on driveways. Okay, so what's James talking about? There's a new law that's been passed that basically says, look, if somebody lives in an HOA and they have a car that's their car that they use for business, and let's say that car has writing on the side that says Joe's Plumbing or whatever, and as you know, the HOA would never let that car in. New law is going to say you got to let Joe keep his car in his driveway, right? Leave Joe alone. This is the car he uses for work. Let him park his damn car in his driveway.
That's
right?
what HOA, all the laws are like, leave these people alone.
That's the new laws basically say. This year was the laws that said leave people alone. Like, let them park their damn car in the driveway of their home, right? But James is saying, wait a minute. We don't have Kaufman language. We don't have as amended from time to time language, meaning that our documents do not automatically adopt these new laws. Our HOA is saying this law about pickup trucks, we're not going to follow it. How about that? So the question becomes now, does this new law take away a substantive right of the association? Does it change the contract in a way that basically harms the association, takes away a right of the association? Now, if you're on the board, you're going to say, sure it does. Absolutely. We always had this substantive right to prevent advertising in our community, to prevent cars from making it look like a flea market around here, right? And this new law takes away that very important right that we have. And since we have no Kaufman language, it doesn't apply in our community. Very good argument. And do I think that they would win that argument? Listen, I'm the last guy that argued that argument in front of the Florida Supreme Court. Got my butt kicked 7-0.
Really?
Right?
Oh.
But do I think, I pretty much know this law very well, and I can tell you, do I think the association would win that argument? I do.
You have
I
a
do.
car with writing on it right now because your car is possessed.
It's right,
Not possessed.
exactly.
They didn't repossess
Right,
it.
my car's
it's
in
like
the shop.
Bonkers.
Right, so technically, could they stop me from putting it there? Maybe.
They
maybe.
could.
Yeah.
Now,
so,
my other question, though, you're saying that state law usurps the docs, right?
Yeah,
But you're saying a county law about a dog does.
This judge ruled that the federal law, right, which allows this person to have an emotional support animal for medical reasons, trumps this state law that says pit bulls are not allowed.
But the
He
county
put
law,
federal
you said.
law above. Put federal law above the county law. Yeah, said federal law applies. Federal law is above the county law. In
But
that
you initially said the county law usurped the docs.
no, the judge ruled on that case saying federal law on top, county law on the bottom. So we're going to let federal law apply here. You get to keep your emotional support animal. Here we're saying that because there's no Kaufman language, even though this new law passed that said you cannot have writing on your car, this association said, sorry, we're not going to apply that law in this community because we don't have Kaufman language, and to apply it would be taking away a substantive right of the association to prevent this. We can't do it anymore. You're harming us. You're changing our contract. Do I think they would win? Yes, I do. Yes, I do.
Wow.
So again, these legislators, I will tell you, like Vicky Lopez helped pass this law. And, they think that just because a new law passes, they save the entire HOA world, right? People are going to love us for it. And the truth is, almost no HOA, none, have the Kaufman language.
Oh.
So the reality is that law, James brings up a really important point, that law technically will not apply. Boy, I'm sorry even saying this, but technically that law will not apply if the association doesn't want to apply it in every single HOA in the state of Florida.
You buried your lead. That's kind of a big deal.
Can you imagine? It's a very big deal. All these HOA laws that are getting passed, can you imagine the legislators don't realize that if there's no Kaufman language in the deck, almost none of what they did will apply in the community.
And how
it's
can
as
an
if it
HOA
happened for nothing.
homeowner find out if they have the Kaufman
Gotta
language?
look first. I mean, that's why, do I think what the Supreme Court did was the right move? Absolutely not. The Supreme Court, when I argued the case, could have said, wait a minute, we need to make a law here that says, for the good of condominium laws throughout the state of Florida, we're gonna hold that all condominiums are guided by 718. We're going to hold it all HOAs are guided by 720, no matter what. To now have to look to see which condos have the language, which condos that don't. But isn't it ridiculous?
Yeah.
You would think that every condo should be governed by all the laws of 718. Every HOA should be governed by the laws of 720. The legislature put so much time in making new laws this year, and guess what?
Well, didn't
He
somebody
did it
tell
for
them?
nothing.
Didn't somebody say, hey, by the way, there's this?
They don't believe me. They don't realize it.
Oh, okay.
I had representatives at my seminars on occasion who said to me, "Wait a minute. So you're telling me that the laws that we just passed don't apply?" That's right. They are amazed by it. So do I think eventually this issue has to go back?
Yeah.
To the Florida Supreme Court, and I think the Florida Supreme Court needs to say, yeah, even though we're changing contracts, there's many cases that have been to the United States Supreme Court that says you can change contracts, right? When it's truly for the benefit of the people in the state, it's truly for the benefit of the people in the country, right? People in a community, absolutely. When it's, an overbearing problem that needs to be solved, yes, you can change the contract. And that's what needs to be done here. To have all sets of different laws applied to different condominiums and HOAs, it's ridiculous. It's actually ridiculous. But that happened because of the position that the Supreme Court ruled on in the Kaufman case and in the Cohn case.
And
right.
So this is interesting. This is why they need an attorney.
Yeah, this is beyond confusing now.
Yeah.
Yeah, as to whether or not these laws, what James has raised is so important. And he's right. A lot of associations are going to take the position that all of this that passed this year doesn't apply in our community. If it changes our contract in any way, doesn't apply in our community. Pretty interesting, huh?
Yeah.
All right. Thomas writes in, our board secretary has been removed for being delinquent. The board is giving her time to pay up before filling the position, so there is no secretary. Is this legal?
Good
The
one.
board should, okay, the statute says the board should fill the position. I think they should fill the position. And by the way, under the law, just when someone's off because they're delinquent for 90 days, they don't get to come back on the board when they pay the money.
Oh, they have to
You
be
can
reelected?
fill their position, the board can fill that position with anybody they want. So even if you pay up, doesn't mean a thing.
They can fill it with someone already
With
on
someone
the
else.
board, or
No,
anybody?
they can fill the position with anybody in the audience there, anybody
Oh,
else that
okay.
lives in the community.
Are you a good secretary?
Right. Maggie writes in, why don't you continue the 4-hour Zoom training? Maggie, I have a life also. I can't keep teaching free classes throughout the state. What do I do it like 15, 20 times a year?
For
I teach the
15
free
years you've
classes.
done it.
Right. So, Maggie, I can't keep teaching classes. So what we're going to do, we spoke about this before. Some associations out there want private learning. They'd rather have me come, teach the board, teach the community, and instead of going to a show where it's done in front of a couple of hundred people, some associations say, no, come teach our
Love
board,
it.
yeah,
And
at our
it's fair,
community.
it's more specific
right.
to
Yeah,
their
we can.
needs.
Right, we'll do it specific to our
They
community.
may not have Kaufman language,
Right,
and you
right,
can say, "No,
exactly.
you're
We
screwed."
got to go over their documents while
Yeah,
we're there,
exactly.
right? Exactly. So some associations want me to go there.
So I don't have to
personally.
teach you because it doesn't apply.
Correct. That's how crazy it is. But that's how we're doing it, Maggie. If associations want us to come, we'd be glad
Brilliant.
to come. But I think we teach about 15 of the during the year for free. So that's how it's going to work. Back to the phones.
Let's go to Armando.
Armando, how are you?
Good morning.
How can we help, Armando?
Yeah, good morning. Eric, earlier you mentioned that the new law 718-111 is going to go into effect or has gone into effect regarding record keeping.
Yes.
What is the penalty, if any, if that law is not abided by?
Okay,
by
so
the HOA?
a unit owner can file an arbitration matter, right, against the association. And if an arbitrator decides that the records were not willfully turned over, the arbitrator can enter an order as an injunction requiring the association to turn those records over and issue a $500 penalty against the association and order the association to pay the plaintiff's attorney's fees and costs. So, and that could be thousands and thousands of dollars. So failing to turn over the records can cost thousands and thousands of dollars to the association. Okay, so that's the penalty. And of course, the people who live in the community are the ones that are going to be paying the penalty. But that's the answer to that question. We got to do this, Rob. We got to take our final break of the hour. We're going to go a little late because of what happened in the beginning. 717-452-9378, 717-452-9378. Back right after this.
Is your home or condo looking old, worn out, and in need of a fresh look? Then you need PD Painting to paint your property and make it look like new again. PD Painting will first properly prepare your home and condo and then use only the highest quality paint products. After many years in the painting industry, PD Painting has achieved a reputation for always delivering a reliable and professional finish. PD Painting is fully licensed and insured and offers a 7 to 10 year warranty. Their technicians are expert craftsmen. Let PD Painting handle all the details and then sit back and watch them restore your property and bring back that brand new look and feel. Need a service call? PD Painting will be there on the spot. Need financing? PD Painting can offer that too. Call PD Painting at 888-416-3204. Again, that's 888-416-3204. Go to the website pdpaintinginc.com. Need painting done in your home and community? Contact the experts at PD Painting.
This message is for anyone who has taken on the important responsibility of becoming an officer or director in a homeowner or condominium association. It is also for the management companies who work closely with these caring people to make sure things are done the right way. Hello, I'm Gil Pomar, South Florida Regional President for Center State Bank, now the second largest bank based in Florida. Our bank, Center State Bank, has an amazing team of professionals who are exclusively dedicated to the homeowner and condo association market. Your job is not easy. There are repairs and new projects that need financing. financing. There are legal and social issues that need to be understood. There are also technology and servicing issues that your residents want to be improved. Why not choose a bank that knows this business backward and forward? Why not have a local banker who will meet with you face to face whenever it is convenient for you or your board? Center State Bank has over 2,000 associations as customers for a reason. Please give us a chance to earn your business. Call Terry Russo at 954-633-1666 to make it happen. Center State Bank is an equal housing lender and a member of the FDIC.
Need an insurance evaluation, audit, or quotation for your condo association or homeowners association? If so, then you need to speak with our insurance experts at Mack Waltz. We insure over 800 associations, and we are the clear leader in this marketplace. Mack Waltz has been in business since 1989. We write insurance on billions of dollars of property values. We are an independent insurance agency representing insurance companies which specialize in condo and HOA insurance. The staff at Mack Waltz works closely with board members and property managers and regularly attends association meetings to help educate the association about their insurance policies. To learn more about how Mack Waltz can save you money and improve your insurance program, call now 954-640-6225 and ask for Greg Waltz. 954-640-6225. Mack Waltz Insurance Group. Let us protect your association. And I am with Eric Glazer, who's board certified in community association law. Taking a few more calls, 717-452-9378. You had a good question here about the criminal penalties.
Yeah, our listeners are so smart.
They are.
Andromeda writes in, how about the criminal penalties in the new legislation? Doesn't that apply even if there's no Kaufman language? That's correct. Those are criminal penalties. They will apply no matter what. Correct, okay? You know, like you think about it. All right, we won't have Kaufman language and we'll let everybody steal. No, obviously that can't be the case. So these new criminal penalties regarding interfering with elections, right? Tampering with elections, absolutely. All that will apply. The criminal penalties stay there, regardless of whether or not there's Kaufman language.
Okay.
Okay?
Good question.
Great question, Ann. Okay, who else we got, Rob?
Hang on, let's see. We have... I have to apologize to the viewers in advance. We have an AI machine that transcribes names, and sometimes it's not clear.
Really? So we're using AI?
Yeah.
Well, just blame it on AI.
So
not your fault.
So the next caller doesn't have a name. So let's see if you hear the beep when you...
Nameless, you're up.
You must have a wacky name. AI couldn't even understand it. Go ahead.
Hey, you there? Good morning.
Someone from Palm Beach.
Palm Beach.
Palm Beach, you're there.
All right, let's go to the next caller.
Next caller.
This looks like Mira.
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 Hello?
Hi, Mira. Good morning.
Mira on the wall.
Or Myra?
Hi.
Myra.
Yes, hi. Okay, so I have a question listening to this discussion. So we're a homeowners association, and in the past 7 years, we've had 5 different management companies. Mm-hmm. We have 12 boxes of documents, receipts, everything. And each time we transfer management companies, they take the boxes to their place. So my question is, if a homeowner wants to see them and they can't be provided, the management company has lost them or they don't have them, who takes responsibility for that? The board probably wouldn't, because we don't have our hands on them. So would it be the management company? And
well,
how does that work?
Now it says, so the statute says, number one, let's take this slow. So you're now sitting with all these boxes in your office, right?
I'm sorry, I didn't hear you. What?
You're now sitting with boxes in your office, right?
Well, they're sitting. Some of the management companies they have a storage unit that they store them in. Some of them store them in their office. One of them, she works out of her house, so she puts these boxes in a storage unit. But yeah, so each time we transfer, they go and get them and take them to their facility wherever they want to store them, and they keep them until the next management comes along. And, and that's what we've been doing for 7 years. So, there's no guarantee that they would be available.
Right.
Who's responsible for that?
Okay, so those records, number one, now have to be sorted through and they got to be maintained in a condition that it's very easy for people to find what they're looking for. That's number one. Number two, if somebody comes in and asks to see a record, and that record does not exist in those boxes, yet you are required by law to have that document. Now, the new statute says it's going to be up to the board to make a reasonable effort to find that document now. So you're going to have to go and call your prior management companies and say, hey, we're missing this document. We don't know if it was turned over or not. Can you get it for us? And I'm sure every management company that you talk to is going to tell you we turned over everything we have, right? That's what they're going to tell you. But what I would
that's
do...
what's going to happen. Well, we gave it to them.
Right,
It's their responsibility.
listen.
And the last person with the boxes is going to, I guess they're the ones that's going to be holding, the ball on this
Right,
one. But
but
if they
you-
don't have it, then what does the homeowner, what's the next step? The homeowner, then you're going to sue the property manager, sue the board? What would they do? Or just say, okay, fine, and let it go? What would happen?
They could have a right to sue the board, to sue the association. Absolutely. But what I would tell you is to make an effort to contact your prior management companies and keep track of the efforts that you have made, because again, the statute now requires it. Okay, that's all you can do. Okay, you can't make a document appear that isn't there, but the statute now requires you to at least use your best efforts. Okay.
Okay. Well, thanks so much.
Thank
Appreciate
you.
it.
You got it. Okay, Rob, who we got?
See, the next caller is the one that we just went to that seems that they called back. They have a question about association's right to withhold maintenance. So if you hear the beep.
Hello?
Yes, hi. Who's this?
Hello?
Yes, who's this?
Oh, hi. I have a question on my
Hold on,
association.
who is this?
Do they have the
Hold on.
Do they?
Hold on. Slow it down. We want to know who you are, and we want to know where you're calling from.
Hi. West Palm Beach.
And your
My name is Lynn.
Hi, Lynn from West Palm Beach. How could we help you?
Hi. Sorry about that. Can
okay.
my association for 6 years now withhold maintenance requests because there was pending litigation that was settled?
What
Do they have that right?
What do you mean by withhold maintenance requests? Explain it to me.
And are you a
Let's say if you ask for the exterior common element door light to be replaced because it's pitch black at night.
Right.
They refuse to do that.
Ooh.
When you've given them stuff for the balcony, which is minor, for cracks in the tile, with the structural damage from the litigation, I have a column that is cracked, and I have lots of other cracks in my interior that should be repaired now that the settlement has come through. But did the association have the right to withhold maintenance on units
Absolutely.
pending litigation?
The answer is absolutely not. And an association would be crazy to purposely do that while litigation
What if
is
you
going
fell?
on. What if you fell? What
Because
if
it
you
was
got
dark
mugged,
and
right? Yeah, I mean,
So, Eric,
yeah.
here's my question to you. I have extensive documentation, extensive. There is nobody in the state that, investigates. I need somebody on a national level to look at the documentation that I have, because I have also found this. A board member has written a letter last year to me giving me improprieties of the board. As an example, there is a bill for $54,000 for a water line break that may have been done because of the board's directing a contractor to do it when they should never have done that. I also found bills where the litigation was supposed to have been done under contingency. I found a attorney bill for approximately $4,500 that I think has to do with the litigation inspection of buildings. And I also see it in his 250-page structural damage report where the company inspected the building.
Okay. Couple of things. Couple of things. Wait. Hold on. So we gotta answer these really quick. So, in terms of not providing you maintenance, that's crazy. Especially not providing you with a light. That's
the board
insane.
would be liable.
Absolutely. Not only that, if you, God forbid, something happens to her,
individually.
I would go after them individually.
Yeah.
I'd go after them for punitive damages, etc. Just because you're suing them doesn't mean that they could stop maintenance. As a matter of fact, a lot of times I'm asked, hey, somebody is suing the board. Can they get on the board? Can they run for the board?
Oh, yeah.
And the answer is yes, absolutely. No two ways about it.
Sounds like retribution.
So in terms of bills that you have found for attorneys, I will tell you that apparently you have sued the association, right? So what they saw, somebody sued the association. Hold on, you said there's litigation. So once there's litigation, hold on.
Common element.
Shut her down, okay? So once there's litigation, okay, the association takes that complaint that they get served with, and they have to turn it over to their insurance company. Their insurance company now should defend the association for free. She said she found a report, like a structural report, and it cost $4,500 to do that. What probably or could have happened is, since the association was sued involving a case with structural damage, the association went out and hired an engineer and paid $4,500 to investigate the claims that were made in the complaint. Okay? And on that note, anybody else, Robert?
Let's see. Let's go to another caller that didn't leave the name or didn't come up. So if you hear a beep right now, you're up.
All right, Nameless. How are you?
Yes, hello.
Good morning.
I'm Helen. Good morning.
Good morning, Helen.
Helen from Miami Beach.
Thank you.
I'm calling regarding our condo association that hired a new management company, and one of the reasons for that was because they do have a third-party portal where we could upload documents.
Great.
However, subsequently, they have decided which documents they are going to upload and which they will not, including monthly financials, for example.
Right.
They do prepare monthly financials by contract, but they've decided they do not want to post those on the portal,
right.
Meaning that we have to file a records request for those.
Right.
What documents are required to be put on a portal?
So there's very few that actually are required to go on the website. I can actually try to look for it while we're on here. But I don't understand that you say they have refused, because I just don't understand that.
The CAM.
They can't refuse.
No.
They shouldn't be
What
refusing.
are they running the website, the CAM? Do they have possession of the website?
Well, they do. They can post, and they can make edits. It is run by a third party, however. So I don't know. Somehow in concert, they do it together.
Okay.
Okay. So here I'm looking at the statute. This is what has to be on the website. A current copy of the following documents must be posted in digital format on the website. The recorded declaration of condominium and all the amendments, the bylaws, the articles of incorporation, or other documents creating the association and all the amendments to that.
So if you want to see if you have coffin language, just
You
go to
can
the
look
website.
there, right. The rules of the association. Now, it doesn't say the contracts. It says a list of all executory contracts or documents to which the association is a party or under which the association or unit owners have an obligation. After bidding for the related materials, equipment, or services has closed, a list of bids received by the association within the past year, summaries of bids, the budget, the financial report, and any monthly income or expense statement to be considered at a meeting.
Then it needs to be there.
That's interesting what she said. So this says the financial report required by subsection 13, that's the year-end financial report, and any monthly income or expense statement to be considered at a meeting. So if that monthly income report is to be considered at a meeting, in other words, you have a monthly income report, right? And one of the things...
It's called a monthly financial.
Okay, right. And let's say on your agenda for the meeting, it says discussion of monthly financials, right? So according to the statute,
But they don't do that.
Okay, then there you go. Now, if you put it on there as an agenda item, then to me it would be required to be put on the website. Okay? Then you asked what else has to be up there. The certificate of each director showing that they're certified. All contracts or transactions between the association and any director. Any contract or document regarding a conflict of interest. Notices of any unit owner meetings and the agenda. No later than 14 days before the meeting has to be posted in plain view on the front page of the website. Okay, and notices of any board meetings and the inspection reports, and that's it. That's it. So under the statute, right, there's actually very little that is required to be put on the website. I mean, other than your governing documents, there really isn't much. So do I think that that's not enough? Yes, I think that's not enough. I think a lot more records should go on the website. And as a matter of fact, we're going to have some news about that, Robert, sooner than later, right? Because I'm getting the feeling that a lot of people are just very unhappy with the way their websites are being run. Really unhappy. Like, for example, this particular caller. And Robert and I might have some surprising news, so hang on in that regard, okay? We might be able to help, okay?
And could
yes.
Just one little, to button this up, could the board require that management post those documents on the portal?
Yeah, why not? I mean, look, I don't know what the contract says, but what's the big deal to post it on the portal? Why is that a big deal?
Right.
Why is there even a fight about it? Why is there a discussion about it? You say to the company, do me a favor, just post the monthly financials, and they tell you no? Well, it's time to get a new company.
Yeah.
Time to get a new company.
All right.
Okay?
Thank you.
Thank you so much.
Thanks.
Any more calls, Rob?
Bye.
Bye.
Yeah, we have our last caller will be, I believe it's Dawn. Let's see.
Look, I don't know what the contract
Don, you there?
Hello?
Yes, good morning.
Yes. My name is Dawn, and I was wondering if the board or management is allowed to determine people's monthly maintenance or assessment based on the style of their unit and not the square footage.
I don't know what style means, but here's how it's determined what people pay, okay? There is a page in your declaration of condominium, right? It's in the back. It's one of the exhibits to your declaration. And it's broken down either, let's say there's 10 units, okay? But some associations would say, okay, everybody pays 0.10, 10% of the budget, right? Because there's 10 units, everybody pays 10%. That's one way of doing it. Or it could be, if let's say there's 5 bigger units and 5 smaller units, it could be that in the back, that page you're going to find, it shows that the bigger units pay a little more than the smaller units.
I thought everybody
okay?
paid the same.
But there's a page in the back of your declaration that's an exhibit, and it shows exactly the percentages that people have to pay. It's in every declaration. Okay? Sometimes it's exactly the same. Sometimes it's a little different based on square footage.
But she's saying the design is different.
Yeah, I don't know what design means. Design means maybe square footage is what she's talking about. So yes, it's possible that if one, bless you, that the bigger units do pay more. You have to check in your governing documents. On that note, okay, so we apologize for the technical problems in the beginning, but we stayed later for you guys to kind of clear that up. We apologize again.
Today.
I'm sorry? You learned so much today? Yeah, I'm tired. I got to admit.
I've done this for 15 years and I learned a lot.
This is great questions by our listeners today. Smart people. We so appreciate it. Just to remind you, if you need legal help off the air, please give Glazer and Sachs a call, 954-983-1112. Again, 954-983-1112. We wish everybody a wonderful, safe week, and we'll see you and speak to you again next Sunday here on Condo Crazy, everybody. Okay, Mother's Day. Have a great week, everybody.
Thank you.